Give the call to the member for Lingiari.
Thank you, Speaker. My question is to the Minister for Employment and Workplace Relations. What is the impact of the Albanese Labor government's amendments to the Secure Jobs Better Pay Bill?
Give the call to the Minister for the Leader of the House.
Thanks very much, Mr Speaker, and I thank the member for Lingiari for the question. Somebody who knows that whether workers are in the cities, in the regions or in remote areas, it's about time they had a pay rise, and I thank the member for the question. It's clear from the negotiations that have been going on for some time and that continued over the course of the weekend that this week the Secure Jobs Better Pay Bill will become law. In doing that, I want to take the House through some of the amendments that have been agreed to by the government in the negotiations both with the Greens and with Senator David Pocock. While consultation continues with all crossbenchers, I want to go through what's now been agreed and what secures passage of the bill. I want to thank the member for Melbourne and Senator Barbara Pocock for the negotiations that have been taking place, which will lead to amendments that make sure, with respect to some further amendments to the Better Off Overall test, that it will still be becoming simpler and fairer, but specific amendments to make sure that there is a guarantee that no worker can be worse off. And I also want to acknowledge the amendments, that's something that Senator Barbara Pocock has pushed for a very long time, to improve flexibility at workplaces, including arbitration on unpaid parental leave. The amendments that Senator David Pocock has pursued to the bill go to a few areas, but many of them focus on the impact on small business. By taking in the single interest stream the small business exemption from 15 to 20 employees, it means that 97.5% of Australian businesses are excluded from that stream. 97.5% excluded if they want to be excluded, but obviously the right to opt in remains there. There will be a statutory review of the legislation 2 years after the bill, within 2 years of the bill passing. I note that that by 2 years we'll know whether or not Senator Cash was right and whether Australia had in fact been completely shut down. But we're bravely waiting 2 years to be able to have the statutory review. There'll be an increase in the period in which the Fair Work Commission there'll be an increase from 6 months to 9 months from the expiry date, where there's a history of effective bargaining before an employer can be brought into a multi-employer bargaining. In the single interest stream, the Fair Work Commission will have to be satisfied that the various employers within there are reasonably comparable. Similarly, there will be an easier way for employers, if they don't want to be part of a multi-employer bargain, if they have fewer than 50 employees, for that case to have to be made by others to the Fair Work Commission rather than the onus being on them. With all of these different ways, it basically means the sky that will fall in arguments from those opposite. While I know they'll continue to make it for the rest of the week, people know it's not true. People know it's not true, and this bill will deliver.